So in the previous recording, we were looking at what would happen if one of the parties breached their obligations under a contract. And we talked about damages and orders for specific performance and so on. However, in some situations, it may be that one party hasn't fully performed his obligations under the contract, but it's still not possible to bring an action against him because that contract contains a valid exclusion clause. Now, an exclusion clause is defined as any clause which purports to restrict or exclude liability for breach of contract or negligence. Well, excluding liability, we all know what that is. It's a clause that says we are not liable if we get it wrong. But a clause that restricts liability is a little bit more subtle. This is a clause that says we are only liable if, for instance, defects are notified to us within 24 hours of delivery or something like that. And basically, those clauses can cause all sorts of issues. You may not be aware of the defect within 24 hours of delivery, for instance. Now, as a basic rule, the courts don't like exclusion clauses. And the reason for that is it kind of seems against the purpose of the contract, doesn't it? You know, you have a contract agreeing to do something which creates legal obligations. If you can then get out of that by just writing in the same contract, but we're not actually liable, it kind of makes the whole thing seem a little bit pointless, doesn't it? So the courts have developed a series of tests to try and make sure that exclusion clauses are interpreted fairly narrowly. So first of all, let's look at the common law position. This is called sometimes the incorporation test. To be enforceable, an exclusion clause has to be an integral part of the contract. It has to be incorporated into the agreement that the parties have entered into. Now, there's different rules here depending upon whether you have a signed document or not. If you have a signed document, the basic rule is you're bound by it. It doesn't even matter if you've read it. It doesn't matter if you can read it. The fact that you've signed a document means that you're bound by it. And that usually will apply to the sort of electronic signature where you tick the box on a computer screen as well. However, if there is no signed document, then we have to look at three tests. The timing, whether the clause was communicated or not. Now, timing is important, first of all, and the case on that is the Ollie v. Marlborough Court hotel case. So in this case, a husband and wife had booked their hotel and they booked it in advance. They arrived at the hotel and checked in, went up to their room, and on the back of their bedroom door was a notice which disclaimed liability. Now, what happened in this case was that Mrs. Curtis had a very expensive fur coat and it was stolen due to the hotel's negligence. So they tried to claim some damages. But the hotel said they weren't liable because they had an exclusion notice. Now, in this case, the hotel couldn't rely on that exclusion notice because it wasn't communicated to Mr. and Mrs. Ollie at the time or before they entered into the contract. They didn't know about it till they were actually in their hotel room way later than the time when the contract was made. Therefore, it wasn't incorporated into the contract and it couldn't be relied upon. The other question there is a question of communication. Was the other party made aware of the terms of the exclusion clause, and were they aware of it before the contract was entered into? Now, the courts have looked at this and they've said that the more onerous the exclusion clause, the more significant it is, if you like, the more the party has to do to make the customer aware of it. So, for instance, if you're just saying we're not liable for damages over £1 million, for instance, that's probably fairly normal. You probably could get away with that one in your small print. But if you're saying we're not liable for any damages howsoever caused in any situation whatsoever, then you'd have to do a little bit more to make sure that the customer was aware of that. Now, the other thing we have here is something called the contra proferentum rule. And what this is a rule that says if there's any ambiguity in an exclusion clause, then the courts will always interpret it against the business who's trying to rely on it. So you have to be very careful if you're going to write an exclusion clause that the wording is very, very clear. Now, in addition to the common law test, there's also two statutes that we need to know. So the first of these is the Unfair Contract Terms Act. Now, it's important to note that this Act applies to contracts between commercial enterprises only. And what this does is it says an exclusion clause will either be automatically void or will be treated as void unless it can satisfy a reasonableness test. Now, the Act actually goes on to define what a reasonable test will be and what we should consider. So we'll look at that in a moment. First thing to note, and this is something the examiner loves to test, this Act doesn't apply to insurance contracts or contracts for the sale of land. Doesn't apply to contracts between private individuals. So if you're selling your car to your neighbour, say, something like that. And it doesn't apply to contracts between businesses and consumers. Okay, so the Unfair Contract Terms Act is now business to business only. Okay, so what are the rules? The first rule is that an exclusion clause which tries to exclude liability for death or personal injury arising from negligence will always be void. The courts will just ignore it. A clause that tries to restrict liability for any other loss arising from negligence is void unless it can be shown to be reasonable. And it's up to the company or the business to show that that clause is reasonable. So the difference there, let's imagine you have a car park which has some unsafe structure. If a brick falls off that car park and hits my car, then we would be in this category here. We'd be in the category of property damage, and the garage or the car park owner would have to show that their clause was reasonable. If the same brick actually hit me and caused me some injury, we'd be in the top category and the clause would automatically be void. There's also a provision here about contracts which try to exclude liability for the condition as to title. Now, what that is basically a provision that's implied by the Sale of Goods Act, which says that anybody who sells items is assumed to actually own them at the time they sold them. And it's not possible to exclude that implied contract term. So what is this reasonableness test? Well, it's set out in the statute, and it says basically the term must be fair and reasonable, having regard to all the circumstances which were or ought to have been known to the parties, and this is important, at the time the contract was made. Okay, so it's not hindsight. What did you know and what should you have known when you entered into the contract? Now, what sort of things do we have to think about here? Well, we look at the strength of the party's bargaining position. The courts will look more favourably on an exclusion clause if the parties had relatively equal bargaining. But if the party relying on the exclusion clause is a big, bad conglomerate with lots of negotiating power and its own legal department, and the person on the other side is maybe a little old granny, then the courts are much more likely to treat the clause as unreasonable. Was there an inducement? And by that we mean, for instance, did you get a lower price because the exclusion clause existed? The courts do recognise that quite often exclusion clauses are very useful because they allow businesses to manage their risk and therefore to keep their prices down. So if you got a discount because of the presence of an exclusion clause, that clause is more likely to be reasonable in the court's eyes. Did the innocent party know of the terms? Again, it's knowledge. Was that clause made clear? And did the other person actually understand it at the time? The courts are also keen to consider insurance, because you can only take out an insurance policy if you have what's called an insurance risk. So if one side of the agreement is in a position to take out insurance, it perhaps makes more sense than that the other party should be excluded from liability. And the last one is whether any misrepresentations were made. So, was the party relying on the clause above board and honest about the terms of the clause? So it's up to the party relying on the clause to show that, on the balance of all these factors, their clause was reasonable. Now, the next piece of legislation, the Consumer Rights Act, is slightly newer, and this applies to contracts which are B2C, business to consumer. And it's defined to apply to consumer contracts. Consumer contract. and consumer notices. And that's things like signs in car parks and things like that. And because this time we're looking at consumers rather than other businesses, you'll see the provisions are a little bit stricter. Look, any provision in a contract which excludes liability for death, personal injury arising from negligence, or which restricts a consumer's legal rights under the Act will be void and therefore unenforceable. Any other clause could be enforced, but the trader will have to show that that clause was fair. Now, it's slightly one-sided because whilst the consumer can argue that a clause is unfair and should be struck out, the trader can't. And again, if there's any ambiguity in that contract, in that the terms of that exclusion clause, it's always going to be interpreted against the trader. Now, what is this term fair then? Well, a term is unfair, according to the statute, if it's contrary to the requirement for good faith, causes a significant imbalance between the parties to the detriment of the consumer. So the sort of thing we should be looking at here is how clear was the language? Was it written in clear, easy to understand language? And if you can get the sort of plain English, the clarity mark on your document, that may help you here. The circumstances when the contract was signed, were you pressured into it? Did you feel bullied? Were you harassed? Did you have time to consider the terms carefully? And also the nature of the contract. And there's some examples here of how the courts have looked at this. So, for instance, where there is disproportionate compensation payable by the consumer. So, for instance, if you wanted to break this contract, how heavy are the penalties for breaking it early? Binding you to terms that you've not been able to read in advance. So perhaps you've just had a lot of small print shoved under your nose and you haven't been able to read it carefully. What if the trader can change the terms unilaterally? So he can actually just vary the contract whenever he wants and impose new terms on the consumer. That seems incredibly unfair to me. Situations where the trader has been able to set the price after the contract has been entered into. And finally, forcing the consumer to comply with the contract, even though the trader hasn't done so. Again, that's quite harsh and clearly would reflect an unfair contract. Now, the one thing to note here is that although we've said it applies on contracts that are between a business and a consumer, there is this concept here of incidental business use. And we just mentioned that at the top of the paragraph, which is like traders who are engaged in activity which is incidental to their business. So the case law on this related to a case where a husband and wife ran an import-export business and they bought a company car, partly to use in the business and partly for their own use. And in this case, the court said that the Consumer Rights Act applied to this contract because although they did buy it for the business, that wasn't what their business was about. So they can't be expected to have the sort of knowledge of a business person in this text. So that would mean, similarly, if, say, myself as a director of First Intuition were to go and buy maybe a company car or maybe some new sofas for our common room or something like that, I may well be acting as a consumer because that's not really what my business is all about. It's not where my special business acumen would lie. So that brings us to the end of this chapter 2. I'll see you soon for chapter 3.